one of the matters.
Hmm.
And there are two other matters, not which we have filed petitions.
What are you challenging, sir?
Lord, what we are challenging is the appointment, Lord, of the resolution professional. Whether he could have been a resolution professional in the first place, and secondly, whether he could get converted into a liquidator. The issue, my Lord, is very
the resolution professional himself is a liquidator.
Is a liquidator. He becomes a liquidator, and in our respectful submission, Lord, he misrepresented the order passed by this honorable court in the connected matter, where it was a
Which is that connected matter?
That's also listed. That's also listed. Where I have made an application to implead myself. And my Lord said that I have a protection now by virtue of that that instruction which was issued by IBBI, saying, Lord, that the resolution professional can't be the liquidator, because there's obviously a conflict of interest, Lord, in the entire scheme of the code, because it is all about, Lord, ultimately a certain amount of money. CIRP, you recover what is the actual expenses that you incur. In insolvency, when you go to liquidation, you earn not 1.5% of the value of the property. So this whole urge to prevent the CIRP and go forward.
We heard.
Not in the
Wait, sir. All right. Yes. I have not yet heard him in full. I'm fixing a date for hearing. Yes. Yes, ASG sir.
Lord, in WP 27043, Lord, I am for the board. Annexure A is a recommendation, a general recommendation issued by us under section 34(4)(b), instructing that the IRP, the resolution professional who conducted the CRP proceedings, should not be appointed as the liquidator.
Now he is appointed, is it?
But generally, in our observation, the board's job is to monitor the
all such things.
We have seen that the resolution professionals purposely push the matter into liquidation so that they get a high, 1.5% of the liquidated value. So we are seeing this as a pattern, which is why, my Lord, under 34(4)(b), we issued a general instructions. The petitioner, the resolution professional concerned here, has questioned the correctness
of that
recommendation which we have made to the NCLT. So the validity of that will have to be considered.
Permit me. WP 27043, item 53.2 of this point 1 clause was originally filed with a resolution professional challenging a letter issued by IBBA, which is Annexure A at page number 20.
How are you aggrieved by that, sir?
My lawsuit forum and say
you are appointed as a resolution professional, that is not taken away. How are you aggrieved by that communication?
Forum see section 34 of the code. Section 34.
IBC code 1 nimsha. Resolution professional is supposed to be neutral. Yes. This is why problems are happening. Only because of this overindulgence.
Permit me. Only permit me.
Yes, sir.
That has got nothing to do with, say, my petition filed has got nothing to do with my petition.
Correct.
My petition was filed in 2023 itself.
That's all right. Tell me, sir.
Come to 34,
I am at 34.
34 of the code,
Yes, sir.
First 33, Liquidation of liquidation. Section 33. Come to 33, subsection 4. On receipt of an application of subsection 3, if the adjudicating authority has, Lordship, want me to read right from 33(1) itself. Sorry. 33 governs liquidation process. Before the expiry of the IRP, insolvency resolution period, or maximum period for completion of CRP process, as the case may be, does not receive a resolution, but it sets out what are the circumstances revealed, liquidation can be ordered. Then, the last become 30. And section 34 talks about appointment of a liquidator and fee to be paid. 34.
So you want to continue as a liquidator? Yes, sir.
I'm not willing to continue at all.
Then why are you challenging it?
This permit me to complete this. 34(4). The adjudicating authority shall by order replace the resolution professional. So we are not going to liquidation stage at all. The powers of the adjudicating authority are set out in section 34(4). The AA shall by order replace the RP if A, the resolution plan submitted by the RP under section 30 was rejected for failure to meet the requirements mentioned in subsection 2 of section 30, number 1. Number 2, the board recommends the replacement of a resolution professional to the adjudicating authority for reasons to be recorded in writing. And C, the resolution professional fails to submit the written consent under subsection 1. So these are circumstances. Then, for the purpose of classes A and B of subsection 4, the adjudicating authority may direct the board to propose the name of the insolvency professional to appoint the liquidator. Also, for C, the circular which is imbued takes away the right of the committee of creditors and as well as the as per the present scheme of the code, the existing resolution professional cannot continue as liquidator if it can be replaced on 3 circumstances. Circumstance 1, when the plan submitted by the RP was not approved by the adjudicating authority for not complying section 32(b)(2). Number 2, number 2 is if the RP does not give his
that I have seen. Yes.
No, this by virtue of this circular, with the court.
So you want to play a dual role
I am not playing dual.
of RP and liquidator.
I am only questioning.
No, your questioning is all right. You want the purport of the questioning is you want to play dual role of being an RP and the liquidator both.
That's what the court contemplates.
Now the cat is out of the bag.
The court is,
Yes.
that's what the court contemplates.
We'll see. Yes.
My lord, I am appearing for the committee of creditors, my lords.
Yes, madam.
My lords, in this matter, my lords,
Mm.
there was an RP who was appointed previously, my lords,
Mm.
and he had been there for 1.5 years, but due to certain circumstances, he was suspended, my lords.
All right.
Subsequently, this RP had been appointed,
Fine.
and within few short period months, my lords, the COC decided that this matter is fit for going for liquidation, my lords.
Mm.
In view of which we had appointed him, and it was in terms of section 30.
We'll clarify now. We'll clarify. You can't don the role of both the liquidator and the resolution professional.
Irrespective of that, so far as the writ petition filed will not.
That is why this is why the RPs will show undue indulgence and become partisans within no time.
There is another problem with this resolution professional. There's a disclosure requirement, my lord, when you are appointed as an RP. The disclosure requirement is that you must not have any financial interest nor be on the panel of any of the banks who are part of the committee of creditors.
Correct. Yes.
He is part of one of them. He does not disclose it.
I have disclosed it.
No, it's
I have
not disclosed.
I have demonstrated. I have filed my reply. I have demonstrated how I have disclosed.
I have
So
the
there's a
disclosure
manner of
document.
disclosure also. Is
There's
there?
a doc.
Disclosure I have done. IBB is following. IBB is. I have to give all disclosures to IBB. I have done everything.
Not to IBBA. You must disclose it at the point in time when you're being appointed.
That's what is done. I have disclosed this committee of creditors.
No, the very fact that you are challenging the communication of the government board, communication of the board saying that a RP should not be appointed as liquidator shows that you are more interested than what is necessary.
Lordship was
No
pleased.
doubt about it.
Your Lordship was pleased. Lordship,
As far as I know, the law is that resolution professionals should be neutral.
I am always total.
Yes. No, this is not neutrality. Yes. We'll answer. We'll answer the query, no problem. Yes, list the matter, vacating stage, yalla. You have filed vacating
I have
stage.
filed.
We have to answer it. Yes. List the matter on Wednesday at 4 PM for further hearing. Wednesday, or when do you want, sir?
Wednesday, there is some difficulty, either Tuesday or Thursday.
Tuesday at 4, Tuesday, madam?
Tuesday, better.
Tuesday at 4. What is this, sir? You should adjust the. ನೀವು ಹೇಳಿದ್ರೆ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅವ್ರು ಹೇಳಿದ್ರೆ ನೀವು ಹೇಳ್ತೀರಾ
My mother's ceremony.
then fine. He has a valid reason. You don't have a valid reason.
4 PM is okay. 4 PM is okay.
4 PM.
4 PM is
On
okay.
Wednesday.
4 PM.
Wednesday, 4 PM, right?
Yes.
Will Lordships consider 27043 first minutes? My writ petition.
We will take everything together.
Yes.
If you want me to vacating stay, ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ ನೀವು?
That's in the other one. Where, my lord, I'm impugning his appointment as a liquidator. And that, my lord, now he says vacate that and let the CR.
No, we'll hear the whole hog, sir. Yes.
And I'm not intended to be liquidated also. The reason for me to.
Withdraw ಮಾಡ್ಬಿಡಿ petition ನ.
I cannot, I will convince you, Lordships. I will definitely convince you.
Yes.
The board has overreached its powers.
Board has overreached its power. And the resolution professional is saying this.
What I'm saying is,
Yes,
when
sir.
the court says that the RP shall continue as liquidator, and there's a power under section 34(4)(b) for reasons to be recorded in writing, the board can exercise its powers. They have not done it in this case.
We'll do it. We'll steer clear the controversy. Yes.
I will definitely convince your Lordship, sir. I am confident. I will convince your Lordship, sir.
No problem. Yes, you can.
I will convince. I
Yes.
am confident.
Which Wednesday?
Wednesday.
Wednesday, ala? Yes.
4 p.m. Wednesday.
4 p.m.
4 p.m.
List on Wednesday at 4 p.m. for further hearing. Intermodal subsisting in any of these cases shall continue till the next date of hearing.
34.
Early hearing.
The petitioner
What is this early hearing applications?
Lord, the
2025 matterly?
petitioner has some health issues. My lord, the sale deed of the petitioner has been withheld by the respondent authority for 12 years, my lord, on
12 years?
application.
Which authority?
Lord, the respondent number 2, district registrar and deputy commissioner of stamps.
Yes,
Since 12
Jafar. 12 years.
Yeah, regarding calculation of the stamp duty.
No problem. Whatever it
Stamp
is.
duty was calculated. Now
Ah.
disputing the amount. That they do not say.
My lord, the
According to us, the latest guideline, what they are supposed to pay.
Hmm.
We have given out a calculation. They say that is not the calculation.
Lord, the
That's
process
the-
of adjudication was taken up in the year 2012 until this honorable court directed them to consider my representation